All right, let's call the meeting to order. Tuesday, May 14th, Warren County Building Code Appeals. We need adoption of today's agenda. Do I hear anybody? Motion to adopt the agenda.
I'll make a motion.
Yes. All in favor?
Aye.
Those opposed? Item number 3 is the approval of the meeting minutes of the November 8th, 2018 Code Appeals hearing. We have a motion to approve those minutes.
I'll make a motion.
And second? Dave seconds. All those in favor? Signify by saying aye. All those opposed? All right, at this time, I'd like to take just a second to introduce Jason Hand. He'll be the counsel for the Warren County Code Appeals Board today. And Mr. Buracker, if you'd like to read your statement.
On item 4 of today's agenda, public hearing, appeal number 1, 2018, Kristie Atwood. I'd like to disclose the following. I'm an officer, an employee who has personal interest in a transaction as defined by the Virginia Code and 2.2-3112A, pursuant to Virginia Code and 2.2-3115F. I'm disclosing that I am employed by Martha T. Buracker, DBA, Buracker Construction, located at 3452 Bentonville Road, Bentonville, Virginia, 22610, which constructed the home located on 1285 Pilgrims Way in Bentonville, Virginia, 22610, permit number 493-2015 for Kristie Atwood, is subject to this appeal. The transaction is application solely to property or a business or a governmental agency in which I am personal interest. Accordingly, I must disqualify myself from participating in this matter before the local board and building code appeals. I ask this disclosure be made part of the minutes of this meeting.
On item number 4, public hearing appeal number 1-2018, Kristie Atwood. I would like to disclose the following. I am an employee at Cline Construction Incorporated, located at 86 Menifee Lane, Farmville, Virginia, 22630, who has a personal interest in a transaction defined by Virginia Code 222-3112A, pursuant to Virginia Code 2.2-3115. I am disclosing that I did work for Martha T. Buracker, DBA Buracker Construction, located at 3452 Bentonville Road, Bentonville, Virginia, 22610, which constructed the home located at 1255 Pilgrims Way in Bentonville, Virginia. Permit number 493-2015 for Kristie Atwood. That is the subject of this appeal. The transaction has application solely to property or a business or governmental agency in which I have personal interest. Accordingly, I must disqualify myself from hearing this appeal before the local building code appeals. I ask that this disclosure be made part of the minutes of this meeting. And at this time, I'm going to turn it over to Art Sabell.
I understand, again, I'm Jason Hand, that you all have a vice chair, and the building code does speak of a chairman and also talks about in the event that the chairman is not available, which is the circumstance here, that the remaining members are to choose a temporary presiding officer. So if one of you were to make a motion for one of you to be the temporary presiding officer, it can be the vice chairman, or it can be one of you, that would be appropriate.
A motion that Art Sabell is fulfills that position. I second. All those in favor? Say aye. Aye.
Paul, are you keeping the
I'd like to call this meeting to order.
Before we get started, Mr. Buracker, just want to let you know that you can participate as the defendant in this meeting. No decision of the board, but you can act as your own defendant in this meeting. All right, so would either party,
Right, yes.
okay, would either parties have any type of preliminary or jurisdictional issues before we get started with this meeting?
My name is Joel Francis. I represent the Burackers, Buracker Construction LLC. We summarily object to the jurisdiction of this board to hear this appeal. I've stated those reasons in a prior appeal, and I'm happy to state them again. If you grant me the floor, if we need to tackle that later on in this meeting, that's fine as well. But we maintain that this board does not have the authority and the jurisdiction to hear this appeal today, and that nothing should proceed.
Well, Mr. Francis, we're going to have two preliminary issues, and I think for I think we would want you to make some proffer as to what that is today.
Sure. Mind if I?
Well, that's up to you.
Yeah, you can approach the podium. I'm sorry, what's your name one more time?
My name is Joel Francis.
Joe, can we back up for just a second? I think that we need to give the appeal, the person that appealed the decision. I think we need to give them a first chance.
That's fine.
Yeah.
I brought this meeting before the board last year, and this was supposed to be like a new hearing from scratch, so it's not really a rehearing because of the conflict of interest that was found by Mr. Madden. The same list that I sent to Paula, I guess when she first emailed me, is what I wanted the board to consider. Not because of the findings that Mr. Bean found in my house, but because of the negligence that he did not find issues with my home. And when I went before the state technical board in January, they were in agreement that I do have a reason to come to the local board. And I have lots of information to give you if we go forward with this today. I am represented by David Silek, and I received an email from Paula. I did let my attorney know, but we never received anything in the mail from her, or from you guys.
So you received the email that I think is dated April 29th, and did you tell Mr. Silek about it?
I did tell Mr. Silek about it, but at the same time, we have been waiting for Mr. Madden to issue his formal conflict of interest opinion, which we have not been able to obtain.
Are you talking about the Commonwealth's attorneys?
Yes. Yes.
What does that got to do with this?
That's why we're hearing this again.
Well, those two members have now stepped down.
Right, but we were not given his formal opinion as to why they stepped down or what the circumstances were or what we needed to do from there. And we have FOIA requests to his office and multiple emails from myself and from my attorney to his office, as well as I think Paula.
So does that have anything to do with the three members that are sitting up there?
That I don't know, because it was his ruling if the whole thing was tainted or not. I mean, I was not informed.
So I'm clear. Did you file an appeal with the state?
I filed an appeal with the state, went before the state, who ordered the local board, every member, to get a conflict of interest opinion from either Brian Madden or the COIA Council.
And we did that.
Right? And so I have not received any information from Mr. Madden as to what was issued, and that is supposed to be public information.
It's public information, but it doesn't have any bearing on this hearing. It was not a condition that she received those. I was at the state technical review board hearing as well. And a condition of the state review board saying that the local board needed conflict of interest opinions performed was not a condition on rehearing this.
Okay, David, would you like to wait?
Her receiving it has nothing to do with this board.
My attorney attorney would like to address you via telephone.
We can do that. In a
Mr.
minute.
Chairman and members, I had previously scheduled a hearing here in Prince William.
Can you tell him he has not been recognized?
He said you have not been David. David, he said you've not been recognized yet. He said you've not been recognized yet. Hold on just a second.
Looking for an actual ruling of the state board, because I remember reading that too, and I think that Mr. Francis is correct. But I have many pieces of paper here.
The state board said that if he did not find a conflict of interest hearing, it would go directly back to the state.
Correct.
But if it did, then it would need to come back to the local board.
Correct. But the state did not say a condition of this board rehearing it would be that she received those opinions. So whether she received them or not is irrelevant to this board hearing this today.
I have in the final word, all members of the local appeals board who participated in hearings regarding this case must seek a written opinion from the Warren County Commonwealth's attorney or a formal opinion from the Virginia Conflict of Interest and Ethics Advisory Council, FOIA Council, whether their participation in proceedings thus far constituted a violation of the State and Local Government Conflict of Interest Act. And there is no requirement that that be disclosed, that those opinions be provided to Mr. Silek or anybody else. So that's what the appeals board said. So, what we have going on here is a request for a continuance, because even though both the client and the attorney knew about this hearing, they had decided that they weren't going to be here today, because why?
We were under the impression that it was going to go just as it was before.
What was that?
That we were going to have the remaining board members, that we would have the opinion, and it would go forth as that. And David did not think that, he was not I notified him that it was before, that it was a meeting, but he assumed it was going to be like the last time, which was nowhere near what you're seeing today, or how it's being.
I don't understand. Okay. So, but.
No, I have a conflict just the time. That's why I'm not here.
Ms. Atwood, I'm going to ask you to turn the phone down, please.
That's not attorney.
I understand.
Turn my phone down.
But I'm going to ask you to turn it down.
Okay.
You can keep your phone over.
No, they asked me to turn it down. I think that's how my attorney is.
So, you had notice and your attorney had notice.
I had noticed, and the only thing I did was call my attorney. He was not notified that they would have a legal representative here, which is not in the bylaws, which is not stated in any public information. And then we were not told anything about that, so he does want a postponement, yes.
All right, so you want a postponement because I'm here?
If you, Mrs. Atwood,
If that's what works, I'll leave.
Hold on, would you like to speak to them, David? Can he speak on my phone?
No, I'm asking you because he's not here.
No, I'm
You want-
not going to answer that because I'm not telling another attorney to be here or not to be here.
So, but the reason that you want a continuance today is why?
I would like to have my attorney present.
But the reason he's not here is why?
Because he didn't think that. He says there is no reason that the matter cannot be continued until when I can have my attorney present.
Okay, other than the fact that everybody else is here and everyone has notice.
Well, you did ask me for his avoid date, so I have him here.
So here is the situation, guys. The building code says that a notice indicating the time and place of the hearing shall be sent to the parties in writing to the addresses listed on the application at least 14 calendar days prior to the date of the hearing. So it's supposed to be sent to the address listed on the application. Now, we didn't do that. Instead, we sent an email. which is the way that we have corresponded in the past, and she did get the notice, and it's sort of the way everybody does correspond these days. So technically, we should have sent her something in the mail as well. I don't know if that would have made any difference in the circumstance in which we were in. At this point, I think it would be appropriate to hear from the other two parties as to whether or not they are amenable to a continuance of this. And then for the 3 remaining board members to make a decision as to whether or not we should honor this continuance request. It will be up to you guys to decide what to do. We really don't want to do this a third time, but on the other hand, of course, we're all here, and the applicant has admitted that not only did she get notice, but that she provided her attorney notice as well. So, you know, in a perfect world, everybody's time is free, and it's great. That's not the world we live in, but I think it will be appropriate to hear argument of all 3 parties as to why. Maybe we've already heard it from one. I'll leave it to the chair to decide that. But if you want to give her more time to talk about that, she can. That's up to you.
Ms. Atwood, do you have anything further?
I have my items, and I am ready to go forward as long as my attorney is on the phone. However, if I'm not represented by an attorney, I don't feel the board can see represented by it. Well,
So are you telling us that you are willing to proceed today?
David, you guys proceed? Yes.
No, you want to continue.
Okay.
You want to continue.
Okay, I'm going to continue. Sorry.
Okay. Is there anything else you want to say in support of that?
David?
I'm good here, but
He wants to know if there's anything I want to say in support of that.
yes, it's simple. She was not notified in accordance to the law to make her.
Yes, can you hear him?
I
One, she was not notified as the law requires. So whether she got notice by email, that's not what the law requires. First. Second, there needs to be a date when the board knew, and the clerk of the board knew. She was represented by counsel that whatever date she could be clear, and not just that unilateral. But that's not what happened. The clerk or the board, one or the other, decided to unilaterally set a date without conferring with counsel, he is counsel was available. That makes it common courtesy. Makes it common courtesy, and I guarantee every member of the board that if they wanted their attorney to be there, they would expect whatever powers that be to coordinate a date when their attorney is available. And I'm certain Mr. Ham would expect that courtesy as well.
You don't speak for me, Mr. Silek, and that is not the way that this appeal board does business, nor it doesn't work that way. And no attorney's dates were clear. Is that correct? The 2 other attorneys here.
I found out about this last week, and I made time for myself to be here. Thank you.
They said they made time in their schedule to be here.
Well, we would have one here, that's quite common. That being said, there's no prejudice in any party with the continuance of this matter to another case. No prejudice. And, quite frankly, if this is how our county wishes to address this matter, I
we're gonna hear from the other two, so if you can put your phone on silent, please. Okay. Sir.
Thanks, sir. As far as the continuance is concerned, my clients told me about this meeting last week. I have deadlines hanging over my head. But this is a quasi-judicial body, it's a governmental body, and when they meet, and we appear. So I'm here, my clients are here, we are prepared to proceed. If we have to postpone this, that's another trip from Harrisonburg for me. That's more money out of my client's pocket. Just because Mr. Silek says that there is no prejudice doesn't make it so. There's absolutely prejudice if we continue this. We are prepared to move forward today. I understand that this is sort of a de novo review of this matter that occurred almost a year ago today. I think it was May 22nd of 2018. Here we are on May 14th of 2019. So we're starting fresh. For what it's worth, I went to the State Technical Review Board hearing, and Ms. Atwood appeared without counsel, with the same materials that she brought before this board today. She also filed these materials after she was provided notice of this meeting today with the board, so that the board would have materials upon which she would be relying. So she prepared, and she gave the board notice of what she would be discussing. And
I have a point of order. How does he know what I...
Ma'am, please, we're hearing this turn.
Well, this is a point of order to Robert's Rules of Order. How would he know what I was
You
applying
don't get to
for?
make points of order.
Yes, I do. It's in the bylaws.
They get to make points of
So
order.
so any available party gets to make a point of order.
Ms. Atwood, I will come back to you and let you make that point of order
Okay.
after we get through.
anyways, she has proceeded on these materials without counsel before. And then the last thing I'll say is I understand the board's dilemma, and I respect the board's dilemma with regard to notice, being that, one is the letter of the law and one is constructive, factual notice issues. In the litigation world, if the defendant gets notice, regardless of whether it was posted on their door, or if it was personally served, or if their neighbor told them about it, and somehow they knew that they were supposed to be in court on a certain day, and they didn't show up, and I can come in and prove that they knew that they were supposed to be here, the judge says that's notice. They've admitted that they got the email. She admitted that she gave the email to her attorney. They had notice. They knew that we were going forward today. Everybody else knew that we were going forward today. We're ready to proceed. Thank you for your time.
Thank you. Mr. Bean, Mr. Whitman, let's speak.
Just a statement. I have no problems with the report today.
My point of order is how would the counsel for Buracker Construction LLC know what I have sent the clerk? How was that given to him? How does he know I sent them anything?
You've given it to all the other parties.
No, because when stuff has been sent to follow up with other parties, I've not received it.
There's nobody that's been sent to.
I'm talking about before. So if there is a member of the board, they are supposed to have no part that has a conflict. They're supposed to have no part in hearing it and no part in seeing any of the information that is exchanged.
That's true.
Okay, then how did he get information that I sent to Paul? How?
I'll distribute it to the board.
The board member that could not see it.
Which board member we talking about is that?
We are talking about Mr. Cline and Mr. Buracker, because he is the counsel for the Buracker, so evidently his client shared with him that they received information.
I'm not sure that I understand where this information that you think that they got.
He just stated that since I was notified, information from me had been sent to the clerk. He just stated that.
It's the same information that went to the State Technical
No,
Review Board.
it's not.
And the State Technical Review Board sent. What I have here is from the State Technical Review Board.
Did you receive something
And
since?
it's the same information.
Yep.
What I have here is the information that from the previous appeal was sent.
Did you receive anything since the last appeal?
The last appeal.
So she sent me notice. Did you receive
I have not
anything?
received anything from
Paula, did you send anything out to any, all the board members? All the board members?
I had no idea that who was going to recuse themselves today.
Okay, well, there you go. So they have my information. And it was known that Buracker Construction
Okay,
LLC.
what does this
was not-
got to do with the continuing?
This has got to do with it's a mishandling of information. I got railroaded here a year ago when I called point of order and somebody refused to recuse themselves. I mean, this is so not fair to me. Because we have rules and laws and bylaws that you guys are supposed to follow, and I have been getting the royal screw from the local board since this began. I mean, Mr. Hatcher and Mr. Hotek, you weren't here, Mr. Spell, but they listened and they actually understood. But then I'm getting glared at the first meeting because Buracker didn't remove himself like he did today, and the second I asked Cline to recuse himself and he refused. This is completely against my due process and against my constitutional rights. And I'm not having it. So we either postpone today, or I will file a huge lawsuit about my constitutional rights because things were given to the board that should not have been. And it goes right against the Conflict of Interest Act.
So
there you go.
decide if someone should make a motion to continue this or not, and if there is a motion to continue this, you should talk about it in a second and then talk about it.
Mr. Executive Hatcher, you got any input that you like to
So if
put
we
in for the
continue,
motion?
I would have trouble hearing the attorney over that phone. I
We're not-
hardly understand anything.
We're not gonna hear the attorney.
I may be getting old, a little bit hard of hearing, but I can't help that. So, under those cases, if the attorney is going to participate, then I think we need to postpone.
Why did you moving to vote?
I'll make a motion to postpone.
And I'll second that.
Motion carried. All in favor, all signify by saying aye.
Aye.
So, let's get Silek on the phone with his speakerphone here.
He's on the phone. David, you're up.
So, does everybody have their, I mean, we can try and come up with a mutually agreeable date on the spot here, or frankly, the board doesn't have to abide by Mr. Silek's or mine or anybody else's schedules. It's
Most of the bills, saying, let the secretary read the book for the board, so we can see what they are.
sure.
You want to see what our available dates are? While you're doing that, I'd like to, Mr. Architect, would you like to have some discussion? Do you have some discussion you want to do on this? Or would you give with the motion that's passed to continue? Look up the sorry.
Yes, I do. Again, the issue is not related to the continuance, it's related to the information that's in front of us.
In regards to
The opinions that I'm seeing here are strictly the opinions of the appellate, not the building official. It's my understanding, again, not being an attorney, my reading of the Virginia code is that we are making decisions regarding the building officials' rulings on a particular issue. Right now, we have a series of comments, we have a series of cited code violations, but we do not have the building official's opinion. It's my understanding this board should rule on the appellate versus the building official's decisions about the same subject, as opposed to simply hearing the appellate's concerns. So it's my feeling that if we are going to have this continuance, it would make a lot of sense for us to get everything in order, so that at the end of the day, this next hearing actually hears things to the end, and we either are able to make a decision or not. Because my fear is we will hear all this information, and then I will ask the question to Mr. Beam. I don't see any rulings on this information we have. So if this is in order for us to have this discussion right now, I think it would be appropriate to find out if Mr. Beam has seen this information and has many rulings, so that we can confirm or not confirm his opinion. So, if that's you, this is the moment to have that discussion.
You know, I think their position is that Mr. Bean has, that he should have found all of those as violations, and he has not. So of course, Mr. Bean hasn't generated a document that says you didn't violate the building code. And so that's why you just have what you have, and you don't have something from Mr. Bean.
But then we are assuming Mr. Bean's current opinion.
I think so, yes. I mean, I think you are assuming what his opinion is that they're not violations, or else he would have found violations, but it is an odd situation, I believe that.
Because as I understand it,
On an old form, if I'm mistaken.
so, it says a copy of the building official's decision shall be submitted along with the application for opinion and maintained as part of the record. I do not have the building official's decision in writing on these issues.
I would agree with you that it's an odd situation because it doesn't exist. You know,
Actually, there is an exact document that exists, and he went through everything and just said civil, not code violation. But then he went back and found some code violations.
The documents that we have in our hand to hear today, if we had continued, does not have Mr. Beam's comments.
Okay, well,
Correct.
it should have. Well, no, not that, it was another paper that was.
That this is the documents that I received for this hearing, and does not have Mr. Beam's opinions on them.
Well, actually,
So
you would
I
not.
can't.
Hold on, please. Paul, is there any documents that you know that exist? With these?
They were submitted at the first hearing from last year. She submitted those as part of her.
I've got to say, if she didn't submit her whole record, and now she's asking for a continuance, there's definitely prejudice here for me and my client, and potentially for the county. I mean, if the record is incomplete, but she hasn't produced everything that she thought she has. I haven't seen what she's produced.
Paula resent everything. When you emailed me, she resent everything I submitted the first time. So what you have, Mr. Kotek, is what a new item that I submitted to go along with this. But the first one, he either said code violation or civil, is what he put through.
But Mr. Silek took contention that those documents were not from you.
If I may, I think this leads into my jurisdictional point that I was going to make, that according to the building code, this board has the authority to hear appeals from the building code officials' decisions, and not from a third-party home inspector who comes and does an evaluation on a house a year or so after an occupancy permit is issued and identifies potential code violations never identified by the building official, and then brings them to this board to compel this board to rule that there are violations. This board only has the authority to overturn, modify, or reject violations. And if there are no violations before this board cannot act. And
What do you read from?
if you look at section 119.7, it's in the building code regarding local board of building code appeals. The LBBCA shall have the power to uphold, reverse, or modify the decision of an official. That's the authority of the local building code. This board does not enforce the building code. That is the duty of the building code official. This board upholds the building official's determinations, overturns them, or modifies them. Before this board, just like a year ago, there are no violations or decisions before this board from Mr. Bain. What happened a year ago is that Ms. Atwood brought a binder full of alleged violations identified by a home inspector who's sitting in the back that she paid. She brought that binder before this board and said, this board needs to order that there are violations consistent with my third-party report. This board identified 12 of them. 6 of those 12 were overturned at a later appeal brought by my client because there was no code citation appended to them in violation of the building code upon the representation from the building official that no code citation existed for those alleged violations. So what we had was this board ordering notice of violations, which is not
Point of order.
which is not
Was
what
that ever ruled upon by the board? That's the one about that jurisdiction issue that you're in now.
This board did not rule upon it on the second appeal brought by the Burackers. I raised the same argument again at the State Technical Review Board, but they kicked the issue back due to the conflicts issue, and they never made any kind of decision or ruling upon that jurisdictional argument. But I can walk you through the duties of the building official and their certain qualifications and what the building official has the authority to do, and then what the local board of building code appeals is given the authority to do. And they're separate tasks and separate functions. And this board does not have the authority, I contend, to find that there are code violations. To go out and say, where there was no violation previously, we are now deciding that there is one. That is the building official's duty. This board is only here to uphold, overturn, or modify decisions made by the building code official.
So, what you can do with this is you can rule today on this jurisdictional issue. You could provide, we could choose another date, and you could say, hey, within the next 10 days, you will provide whatever materials you want in support or against this jurisdictional issue. It would be most fair to allow all of the parties to address this in that manner, but this is up to the pleasure of the board.
Just make a motion then to hear this, based on what Mr. Buracker has presented with us, so we'll hear it at the next meeting. I'll make a motion. Dan, discuss anything before we...
May I make a point of order?
I understand that this board has already voted on continuing this meeting, and I understand that is a final decision by this board. I want to, at least for the record, my objection to jurisdiction to be on record now, and if we decide that we're going to have a later date scheduled down the road, you'll hear me again making the same argument that jurisdiction does not exist for the board to hear this appeal brought by Ms. Atwood.
So I'm working on what she said. I make a motion that the documents that are provided to us.
Well, hang on. Not to be rude, he has moved that this jurisdictional issue be considered by the board at the next meeting, and that hasn't had a second to it yet. We can certainly get to what you want to talk about too.
So, on the issue is the sentence. Can I read it just so I understand before I...
Yeah, I understand.
the LBDCA shall have the power to uphold, reverse, or modify the decision of the official by a concurrent vote of the majority of those present. What is that's what it states. Our jurisdiction discussion, I'm not clearly understanding what we're discussing. What will we be discussing?
What we'll be discussing is whether or not you have the power to decide, and you give potentially the other folks the opportunity of providing the legal authority of argument they want to provide. You know, it's kind of the point that you raised to me before the meeting. You know, where is the decision of the building code official? Well, it doesn't exist. The argument is that the building code official made a mistake by not issuing a decision. And so, Mr. Francis's argument, just summarizing it briefly, is that you can't do that. There has to be an appeal from an actual decision made by the building code official for this board to have any authority. And he has cited this 119.7. And there's a motion that this be considered at the next meeting. And I will also suggest that depending on what the date is set, some deadline to be set for all the parties to provide to you guys any material they have in support or against that issue before the next meeting.
Who's making the motion or the decision? Who made that motion? I do. It's not the same.
Correct. So now discussion.
So Mr. Amon, what I'm understanding is I think this relates back to a question. We can have Mr. Bean then present us with his side of his findings. Is that
Mr. Bean is the ability.
That's right. And prior to the meeting for us to review.
Well, that's another issue. And I don't think that's appropriate. I mean, this was supposed to have been heard today, and it's being continued at the request of one of the parties. If all the parties agree that we open everything up again and let people submit things, that's one thing. This board could decide to do that if they wanted to. I'll tell you that's not the way it would normally work. I mean, if you were first, no, there's nothing normal here. But I mean, first of all, if you had been given notice of a hearing and there was a court date, the judge probably wouldn't give you the courtesy of continuing it if you didn't show up, because even though you had notice, but maybe you would. But if he did, he definitely wouldn't then say, oh, and by the way, now you can give us all some extra material as well. Unless, but again, this is a quasi-judicial board. It's not a court board. We're trying to get as much information as we can.
And I personally don't think we can come to a conclusion until we have Mr. Bean's written statements. So regrettably, the next hearing, I would make a motion that if we don't have adequate information to make a decision. So we would yet again be continuing it because of lack of information. So it is my feeling that once and for all, we should resolve this to the point where we can move forward.
So at this point, we've got, can we table that just for a minute? Because we got a motion and we have a second. We have not yet voted on whether or not we are going to hear argument on this jurisdictional issue at the next hearing. So it would be appropriate now to have a roll call vote on that issue.
So let's vote on that. All in favor of having this jurisdictional issue at the next meeting, signify by saying aye.
Aye.
So, what are the parties' views on opening up the evidence again and providing pre-submission, additional pre-submission information?
I'm fine with it, because that's what I've been asking Dean to do since the beginning.
Mr. Francis.
I think therein lies the rub, right? If there was no notice of violation issued, there's nothing to produce. It's similar to a FOIA request. It's like you don't produce what you don't have. And so if Mr. Bing conducted the final inspection and issued a certificate of occupancy, and that was it. And now she comes a year after entering the house with a list of alleged code violations, and then asks this board to come and rule that they are code violations when he doesn't have any violations to bring before you to decide upon. We're stepping outside this board's jurisdiction. And the other problem that we have now is now we're a year past last year's appeal, and that appeal was brought a year or maybe 2 years after she started living in the home. Who's to say that some of these alleged violations aren't wear and tear on the house after living it for years and years? I mean, we're so, I mean, you know, going back to a litigation issue.
So, Mr. France, let me interrupt you.
Sure.
Mr. England, does this fall into a conflict with the guidelines times?
No.
I was hired 10 days ago, a week ago, to fix any of this. Yeah, I mean, there is a requirement that this be done in a timely fashion because of the fact that it's going up to the appeals board, not coming back to that. I don't know the answer to that.
Per the appeal board, this was how, they wanted it done within 30 days, and it was delayed by Warren County and the Commonwealth Attorney. So I am well within all of my time limits to file.
I'm not making a statute of limitations issue. I just want the board to recognize that we're talking about alleged code violations that have not been determined to be actual code violations by the building official, and the owner of the home has been living in the home for years now and is bringing these before the board.
Mr. Francis, I hate to interrupt you, but my code violations don't require me to build 3 big pipes that run from the outside into my house to have a rapid.
Could we ask Mr. Bean
Yes.
his opinion? I would like to get Mr. Bean just to state, do you feel that this board, based on, you have had the packet that was received on Friday? It's my understanding that that is the information we're here. Do you feel that it complies with the USDC? A copy of the building official decision shall be submitted along with the application for appeal and maintained as part of the record. Do you feel that we have a copy of your decision on these, whatever they are, topics, that we have available to us in order for this board to do what we are supposed to do, which is uphold, reverse, or modify your decisions by concurring vote of the majority?
I would ask a question, if you can read the original appeal application.
And let me
The very first paragraph.
review of possible code violations and construction deficiencies. More importantly, home build does not match county approved plans. Review, and consent to Buracker's construction. See attached third party inspection.
Does it indicate that it's been never given? I'll stand on that.
In the packet that was originally sent, okay, well, Mr. Stanley, the one that Paul sent to you guys, Mr. Stanley made him go through and answer each of my questionable ones, and he had them all saying civil, not code, civil, not code, civil, not code, but he did not come back out and reinspect. And that's what I asked him to do at the beginning.
So we have decided to continue this, and we have decided to continue also to hear about this jurisdictional issue. And I would suggest that the board accept submissions from the parties with respect to this jurisdictional issue, because this is a item that's been brought up today, and everybody should be given an opportunity, if they choose, to send something to us. Is that something that the board would like to do?
I think so, yes.
So let's find out what the dates are going to be, and then we'll go back.
Does that occur?
first available boardroom date is Tuesday, June the 4th. I would suggest at 3:30.
I'm not available then. Tuesday, June the 4th.
I have a matter in Broadway that evening. So we got 2 conflicts already to be closed. What's our next date?
If you could push the hearing up earlier, the BZA is in the boardroom on that Thursday, the 6th, at 6 o'clock.
Yeah, I'm gonna have to disclose this now, you know, I'm getting married in 2 weeks, and I'm going to Italy in 2 weeks after that, so, it needs to be after the 12th of June for me. And if there is no mutually agreeable date, then we could take a 5-minute recess, and I can see if there's one of my firm that could also cover the meeting on a date that we're really, if we really do that. But it seems like the 2 dates were only a week away from what I would do anyway, so.
I mean, we could go out to, again, Tuesday, June the 18th, of the Board of Supervisors is in the meeting room at,
I have a conflict with that.
Thursday, June the 20th. David, is that not good for that? June 20th. And what time would that be on June the 20th, at 3:30? 3:30. We'll make it work.
How much time does Mr. Silek want?
Mr. Hancock asked, how much time would you like?
I want money.
Half of the amount of time that you were allotted.
What?
Half of the amount of time that you are allotted to the meeting.
Half of the time we're allotted to the meeting.
You get
I'm asking him because I've had experience with him in the past where things sometimes take a long time. How long he thinks this will take is a reasonable question.
He wants to know how long you think it will take. He said at least an hour.
And you said June 20th doesn't work for you.
The following week, I'm out, I will be into July.
First week of July is there.
July what?
We, again, 6 o'clock BZA is on Tuesday, Thursday, before. We will be looking at Tuesday, July 9th. Final open boardroom.
We did it, we double booked with BDA, we had a hard time on it.
That may not be good.
He won't be, David's not in town.
I mean, there's,
I'm going.
okay, Thursday, July the 11th.
Thursday, July 12th.
July the 11th, and then it's
Thursday, July the 11th.
He's on vacation that whole week.
Board of Supervisors, and it's Tuesday, Thursday, the 18th.
Thursday, the 18th of July. He's fine with that.
Sure am.
Anybody else have conflict that day?
Yes.
Not that I know of at this point.
Does anyone have conflict with the 3:30 time instead of 8 o'clock?
Why would you want to get there?
And concerning 5 minutes,
Okay.
our additional board,
Sure. Is there a hard deadline for that 3:30, for that Thursday evening?
yeah, and boardroom's open all week.
Mr. Francis, any conflict with that? No conflicts. Mr. Dean?
Those not up here? No.
No, sorry. We were on something.
18th at 3:30.
July the 18th, Thursday, July the 18th, 3:30 p.m. And it is acceptable for Mr. McFadden to join the board, correct?
I would think so because we haven't proceeded with any discussion about any items, correct?
I'm going to think about that. We'll set the meeting for 3:30. Well, I'll ask the parties. Anybody have a problem with Mr. McFadden? The applicant is shaking her head no. Mr. Francis?
No objection.
Okay. Mr. Whitmer? No objection. Okay. So in that case, yes, we'll follow that. So one of you will need to make a motion to continue this meeting until 3:30 on July 18th.
I'll make the motion to continue the meeting on July 18th, 3:30 p.m.
I'll second that.
All in favor, say aye. Aye.
Now, I would suggest that we provided some deadline by which they are to provide you information on this jurisdictional issue. And
So that gives us,
there's lots of time here, but
I'll look at it early possible.
yes, that would make sense to me too.
Alright, I'm gonna make a motion that, all parties have their information, sent in to the secretary no later than end of business day on, June 14th, which is 1 month from today. After, also make sure that it's shared with all of the parties that do not have a conflict of interest. And after that time, we will not accept any more information.
This pertains only to the issue of jurisdiction.
Correct.
Is there a second to that?
All in favor?
Aye.
Is there any other discussion that the board would like to, before we close this out?